Is it Zakila Hill Wetset?
We're ready in this matter.
Welcome to Trial Truth, where everyday courtroom chaos turns into jaw-dropping real-life drama. Today's docket is packed. From missed Valentine's chocolates to violent altercations, Judge Simpson presides over a morning that swings between humor and horror. In the opening moments, we already sense the unpredictability of courtroom life. The calm good morning barely masks the tension bubbling beneath. Each case tells a story: a man's freedom, a mother's safety, a judge's patience. These early exchanges show the gears of justice grinding through confusion, miscommunication, and emotion. The camera might not shake, but the stakes do. Every detail, from a defendant's tone to the judge's pause, matters. And by the time you reach the end of this session, you'll see how quickly one courtroom can move from mild embarrassment to life-changing rulings.
Good morning, I'm J. Kilwald, Your Honor. I'm on case 24F10080.
Good morning. I'm going to assume the box of Valentine's Day chocolates I sent you didn't arrive.
They did not. They did not.
Anyway, out of love in this court this morning, Judge.
One Brown Deputy Chief Public Defender being with Hill with them.
On these cases.
Just go ahead and put your name.
Actually, they did arrive.
Tell the judge your name.
Look, Kyla Hill, what's that?
Alan ate them.
Huh?
Go ahead.
Let's adjourn and I'll come and talk to you. Okay.
Okay, so Mr. Ballinger, he's sick. Something like that. Mr. J, Mr. Ballinger.
No, I'll wait.
Judge, in these matters, we're going to set this for exam, and we may have a resolution prior to that. We'll notify the prosecutor, but as of today, we're setting these matters for exam.
This exchange sounds procedural, but it's loaded with tension. A preliminary examination isn't just a calendar note. It's the first real step toward deciding if enough evidence exists to bind a defendant over for trial. Notice how Judge Simpson insists on clarity while the defense and prosecution shuffle between uncertainty and negotiation. It's courtroom chess. Each side hedges, stalling for time, testing leverage. The judge, calm but assertive, reminds them that this stage isn't a formality. It determines whether the case survives or collapses. The phrase, "not the normal way we do it," signals a warning, a subtle rebuke to keep proceedings in order. Legal takeaway: discovery must be complete before moving forward. Otherwise, both fairness and efficiency fall apart. You can almost hear the patience thinning beneath the robe.
Is all discovery complete?
As far as we
Yes,
know.
Your Honor.
Well, is there any objection to that process from the people? Because your witnesses are going to be coming. I mean, I'm not.
The risk of being embarrassed. What resolution?
Oh,
Who did you talk to?
Judge,
well, that changes things.
here's the thing, Judge. Can we just set this for exam? If I will, if this court sets out a couple weeks, I will notify the prosecutor within a week if there's any resolution. Judge,
Oh, okay.
can we just set it for exam?
Mr. Brown, is that what you want?
Yes, please.
Okay, I'm gonna do, this is not the normal way we do it, but discovery is complete.
Yes, Your Honor.
Yes.
Do the people have their witnesses available on the 27th?
I believe so. Thank you.
I will be letting Judge Washington know that this matter should be going because they're not supposed to be set for exam unless you're ready to go. But it sounds to me like you're still trying to negotiate, which you should be doing at this stage.
Yes, Your Honor.
Preliminary examination will be set in person, February 27th, 2024, 9 a.m. before Judge Washington.
Thank you.
And continue. Court calls the case of the people versus Eli Green.
Now the tone shifts. We move from scheduling logistics to raw emotion. Eli Green's case isn't about paperwork. It's about violence, family, and danger. His public defender calmly requests an adjournment, But behind that polite tone lies a storm. This is where real-world legal advocacy meets the fragile balance of second chances. When the defense mentions no prior convictions, the prosecution quickly counters with adjudications, a technical distinction meaning past offenses may exist even if not fully classified as convictions. Viewers, pause here. Do you think prior history should always affect bail, or does everyone deserve a clean slate for each case? It's one of those recurring questions in American courts. Fairness versus protection.
Attorney Morgan Barroso on behalf of the people.
Morning, Assistant Public Defender Lauren Turney on behalf of Mr. Green. Mr. Green, can you state your name for the record, please?
Eli Green.
Your Honor, we are asking for an adjournment of the probable cause conference.
Without objection, February 29th, 2024, 9 a.m. bond continued.
Your Honor, Mr. Green would like me to address bond.
Briefly,
He's asking for a 10% provision. If he were released, he would return to his home with his mother. He does have one child. He is working as at a temp agency and would be employed. And he indicated to me he does not have any prior convictions.
response from the people.
That is incorrect. He does have juvenile adjudications, but he also has a pending matter in 14B that is up next on February 26th. My understanding, Your Honor, is that we originally requested $500,000 in this case, and we were issued a $25,000 bond. We are extremely concerned at the nature of this. The victim went to pick up the child during a child exchange, and the defendant pointed a firearm at her face and clocked it back. When officers were on the scene, the defendant struck his girlfriend, said he struck his girlfriend, but denied using a gun.
This is where the case explodes. The prosecution drops a devastating narrative. A child exchange gone wrong, a firearm drawn, and a volatile suspect. It's not just an argument about bond anymore. It's about credibility, safety, and risk. The legal term bond might sound simple, but it's a reflection of trust. Does the court believe this person will return without harming others? Judge Simpson's silence here is powerful. He's listening, calculating. The allegations of assaulting officers, resisting arrest, and endangering a child instantly elevate the case's gravity. A $25,000 bond suddenly feels dangerously low. Imagine being the judge. How do you weigh a man's liberty against a community's fear? Would you increase the bond or give him one last chance to prove he's stable?
The officers tried to get the defendant to come out of the house with the child, and the defendant told the officers he ran away from the scene and left the child alone in the house at the bottom of the stairs. He told the officers he wasn't coming back and to quote unquote come find me, bro. The deputies entered the apartment to make sure the child was okay. They were alone, and the defendant was actually still in the apartment and came at the officers while he was holding the child. The defendant then assaulted Deputy Roberts by striking his heel into his face. The child was successfully taken away and given to his grandparent, but the defendant had tried to flee. He resisted multiple commands. He tried to disarm a police officer before he was finally taken into custody. At the time, I do think it's important to note that he did have the active domestic violence warrant out for his arrest from the 14D incident.
At the time that this occurred?
Correct.
And my understanding is that, and I understand those are all allegations, but I also understand that there were injuries to two officers.
That is correct. Deputy Roberts and Sergeant Hogan.
And did it also during that altercation attempt to disarm the officer from his firearm? I don't know why this bond is set so low, quite frankly. Any response from the defense?
No response from me, Your Honor.
When the defense stands silent, that silence screams volumes. In a courtroom, no response often means the facts are too damning to fight in that moment. Judge Simpson's tone hardens. He calls the bond an abuse of discretion. That's legal fire. It means the previous bond was so lenient it undermined justice itself. He raises it to $75,000 cash. Not personal recognizance, not partial payment, but solid cash. For viewers, this is judicial accountability in real time. The message is simple. The court system must protect victims and officers, not reward recklessness. Notice the control in Judge Simpson's delivery. No theatrics, no shouting, just authority. It's one of those moments where calm words carry more power than outrage ever could.
Court on its own motion is going to find that the bond that is set is an abuse of discretion. Bond is going to be increased to $75,000 cash surety. Court calls case People versus Edward Harris.
Gonna be happening here. And so step down.
And Your Honor, you should have a plea form.
That is correct.
I'm hoping.
I have a plea form that indicates that the defendant would be pleading no contest to the charge of larceny, 200 to 1,000 to 1 year offense. On his successful plea to that charge, count 1 would be dismissed. The people have no objection to a PR bond. Shock.
That, you have a question? Ask me. You have a
I
question?
couldn't hear.
Oh, you
Oh.
want to repeat it?
You can't.
No, I heard you
Okay.
looking at it.
You,
Okay.
oh, okay. You were reading my
Would you
lips.
like a device?
Okay, hold on.
Go get a device. For me. Johnny?
Mhm.
Okay,
Okay, wait a minute.
Well,
Okay,
all right.
can you hear me better?
yes,
Okay. All
yeah,
right.
much better.
Pardon?
I hear you much better.
Better. Okay. So the plea form, I'll just restate it, indicates that you'd be pleading no contest to the charge of larceny, 200 to 1,000, a 1 year offense. Upon your successful plea to that charge, count 1 would be dismissed. There also is the people have no objection to you being released on a PR bond. That's the court's full understanding of the agreement.
That's our understanding as well, Your Honor.
All
I
right.
did submit a copy of the police report for Your Honor's review.
Yes, I think I got what I'm saying. All right, very good. May I have him sworn?
Raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Edward Harris Senior.
All right. Mr. Harris, it's this court's understanding you're going to plead no contest to the charge of larceny, 200 to 1,000. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes,
All right. You understand what a no contest plea is?
yes,
All right, let me explain 2 things about it. First thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
yes,
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
yes,
All right. Basis for the no contest.
Civil liability, Your Honor.
All right. Mr. Harris, to the charge of larceny, 200 to 1,000, how do you plead?
guilty.
Okay.
No contest. please.
No contest.
All right. Now you understand that by pleading no contest, that you'll not have a trial of any kind.
We're not having a trial. You're entering the plea.
Yes,
All right. You also signed an advice of rights form today, is that correct?
yes,
All right. Do you have any questions regarding any of those rights?
no, sir.
All right, there should be a copy of one on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
and of your own free will?
yes,
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 238614. Any objection to the court having reviewed that report?
No, Your Honor.
No, Judge, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed.
Thank you.
You're welcome. Pre-sentence investigation and report is ordered at 14A probation. Sentencing in this matter will be
March 13th at 9 a.m.
March 13th, 2024, 9 a.m. That's the bond in this case.
Now comes the comic relief and humanity that keeps these courtrooms from breaking under pressure. As Valentine's Day gets mentioned, Judge Simpson jokes, "I hate that holiday." Laughter ripples through the courtroom. Moments like these remind us that even judges need levity amid endless tension. But under the humor lies substance. He's granting Harris a personal recognizance bond, meaning freedom without cash, only trust. This is justice with compassion. The subtext, redemption, still exists, but it comes with responsibility. Judge Simpson's reminder to come back or I'll have to come get you lands half as a joke, half as a warning. That balance, firm yet humane, defines great judging. It's why his courtroom feels like both a lecture hall and a confessional booth.
Yes, Your Honor. As to bond, we do have an agreement with the prosecutor. There's no objection to a personal bond. We would ask for that today. What's a good phone number to
Don't
call?
I have to agree?
Well, we're hoping that you would, seeing that it
Oh.
was Valentine's yesterday, and I said, please.
You know I hate that holiday.
Oh,
I
Christmas?
don't even understand why it exists.
Christmas?
Because every day with me is like Valentine's. So,
Oh, well, that's so sweet.
Yeah,
Even
isn't
more
it-
reason to do it.
Man.
What's a good phone number? Mhm.
where would he be residing?
Go ahead and answer. Where would you go?
My house,
Okay. And where's your house? Okay.
it's Miami, Michigan,
Yeah.
48197.
Okay, and you're gonna cooperate with my probation department and come back for sentencing?
Yes, I
You
am.
sure?
Yes, I am.
Okay. So if you don't come back, I'm gonna have to come and get you.
I'm coming back.
Okay, all right, I'm gonna trust you.
So, I'll give you the PR. You got-
Mine will be set at a $5,000 personal recognizance fine.
Okay.
All right, Mr. Harris, we'll see you.
Okay, thank you, Your Honor.
You're welcome.
Mr. Harris, you're gonna have to call probation, okay? Call our office if you have any questions. Numbers up here.
Okay.
All right.
And what's your name?
Thank you, Ms. Anderson. I'll put it on.
Yeah.
Can you
Oh.
see the device?
You're gonna try to take my stuff? Okay, all right.
But to get out on those, they're gonna have to put a tether on you, okay? So that's bond with me. So wait for that tether and then call the public defender's office when you get out.
All right. Have a good day. Oh,
Clerk.
that's Ken Overwater. He's your attorney in circuit court.
Oh, you didn't know who he was either?
Probably didn't recognize him with the mask on. See, Mr. Harris,
All right, thank you.
you're welcome.
What started as a mix of chaos and charm ends as a portrait of how real justice unfolds. Judge Simpson navigated everything: missed chocolates, escalating violence, emotional pleas, and moments of comedy with control and clarity. Eli Green's bond increase underscored accountability, while Edward Harris's release proved that trust can still outweigh fear. Each ruling balanced punishment with perspective. That's the delicate art of courtroom truth. In the end, justice isn't just about verdicts, it's about humanity on display, raw, flawed, and unforgettable. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns here on Trial Truth.